This bill is an amendment to the Uniform Child Custody Jurisdiction and Enforcement Act, and witnesses who are here to testify in support of this bill can speak more to the real-world consequences of the way the law is currently written. I'll just speak to the changes that this legally makes. Currently, litigants in family court can agree to designate a jurisdiction as the proper venue to deal with child custody matters. And despite those agreements, the family court has the discretion to declare the designated forum as an inconvenient forum and allow proceedings to happen in another state. Further in this law, it designates foreign countries as other states. So what has happened is that despite a forum selection clause between litigants concerning child custody, courts in Rhode Island have stated that foreign countries are a more convenient forum to deal with child custody disputes, despite that forum selection clause agreement. So what this bill does is it says that a court can still declare a designated forum as an inconvenient forum where that alternative forum is within the United States. However, where that alternative forum is outside of the United States, the forum selection clause will govern. And I think this is a positive change because it recognizes the agreement of the parties and upholds their expectations that they had when the agreement was executed. But it still allows an inconvenient forum to be declared within the United States, just not internationally. Thank you, Chairman.
Thank you. Representative Filippi, are there any Hague Convention issues with this bill?
To my knowledge, no. But I can't say definitively. We've looked at it, and I don't want to state conclusively that there are, but I wasn't able to find any. I know with all uniform acts, we have the ability to amend them to make them Rhode Island specific. But as to whether there's any international Geneva court issues, I can't say definitively.
Okay, my best guess is that there is. I could be wrong, but we'll have counsel take a look at that issue. So let's hear from some witnesses. William Gilbert and Phil McAndrews.
Mr. Chairman and members of the committee, my name is Philip McAndrew. Thank you for hearing us about this important issue. In 2008, my wife, Valerie, and I, the parents of 3 children, divorced after 10 years of marriage. My ex-wife now is an Irish national. My children are U.S. citizens. As part of a consent agreement in 2008, we agreed to Valerie and the children relocating to Ireland. Specifically included in the divorce decree is a forum selection clause identifying the family court in Rhode Island as the site of continued exclusive jurisdiction regarding placement, custody, and support of the children. In 2008, Valerie was aware that she and the children were moving to Ireland, and with that knowledge agreed that Rhode Island would retain jurisdiction over custody issues. Without such a forum selection clause, the consent agreement would never have been made. Despite the distance involved with the use of Skype and other social media, I've remained very active in my children's lives to the point of assisting them with homework assignments and guiding them with challenges. In the spring of 2014, there was a deterioration in the home circumstances in Ireland. My son, aged 13 at the time, reported physical and emotional abuse. Social services, the DCYF equivalent in Ireland, became involved and initiated activity generated at stabilizing things, but to no avail. In July of 2014, with the children in the United States, for their annual U.S. visit, I approached the family court seeking custody and placement of the children in order to protect them from the deteriorating situation in Ireland. Valerie, who in 2008, I will remind you, had agreed to allow Rhode Island to retain jurisdiction, now in 2014 filed a motion requesting a jurisdictional change to Ireland based on inconvenient forum. Family Court, before agreeing to hear our custody case, focused on the jurisdiction argument. Using the guidelines regarding inconvenient forum, Rhode Island Family Court acknowledged that they had exclusive, ongoing jurisdiction, but chose not to exercise that jurisdiction based on inconvenient forum. The court acknowledged the forum selection clause, but did not recognize it with the weight we feel it deserved. Instead, the court ordered the return of my children to Ireland and is allowing Ireland, a foreign nation whose courts don't respect the notion of joint custody, whose courts don't yet allow the voices of teenage children to be weighed appropriately. She allowed them to decide the fate of my children. Rhode Island Family Court is allowing a foreign land to decide whether to return my children to me in the United States. We appealed the family court decision to the Rhode Island Supreme Court, where it is still pending. While waiting for the Supreme Court to hear our appeal, further deterioration has occurred in Valerie's home in Ireland, and my daughter was removed from the home and placed with a relative. She faced a real and impending risk of placement with foster care in Ireland, despite my pleadings that she be allowed to return to me here. We approached the Rhode Island Supreme Court on an emergency basis. The Supreme Court ordered the family court to hear the new emergency case. And with new orders from the Rhode Island Family Court, I was eventually able to return my 14-year-old daughter home as of last week. My daughter spent a total of 4 months in limbo because of a jurisdictional fight. The Irish courts were uncooperative in facilitating quick action in an emergency situation. The family court judge, when reassigned our case, requested an opportunity to discuss the case with the judge in Ireland, with whom she felt would have been better able to adjudicate things. She was told it was not possible. Foreign countries are recognized by Rhode Island Family Court as being, quote, the same as a state. They are not states. They are not obligated to recognize U.S. or Rhode Island law. They do not represent a convenient forum. In fact, in this case, Ireland was not even an equal forum. We had all of this difficulty with a country where the courts operate in our language and have some features in common with U.S. courts. How much worse would it be for a Rhode Island parent dealing with a foreign country that does not speak English, or one that has completely different procedures or extreme philosophies? We are therefore here to provide testimony and calling on the legislature to pass this bill. Thank you.
Thank you, Phil. I'm sure everybody on the committee realizes this is a very, very difficult issue for you. Are there any questions? Thank you, Phil. Mr. Gilbert?
Yes. Hello. Thank you, committee. My name is William Gilbert. I'd like to also testify in favor of this bill, and I'd like to thank the sponsor, Mr. Felipe, for instituting this. Beyond the singular issue that Mr. McAndrew presents with his singular child, the Uniform Child Custody Jurisdiction Enforcement Act, as it's called today, which is, I believe it's Section 15 of our Rhode Island general laws, is a promulgation of years of work on child custody issues. It first originated in 1997, where it replaced the Uniform Child Custody Act. A lot of these acts were devised to better streamline the process of interstate jurisdictional issues, and to allow for also freedom of travel issues, where somebody wants to travel to Florida, but we have custody issues. At what stage and what court would be, the jurisdiction if somebody was to leave? The other reason for the Uniform Child Custody Jurisdiction Enforcement Act, changed in 1997 from its previous act, was exactly the issue I think that was raised by the chair, was there were some Hague issues regarding the Parental Kidnapping Act. It didn't go far enough to address parental kidnapping. I believe the Uniform Child Custody Jurisdiction Enforcement Act alleviated those issues, but as Mr. McAndrew was talking about, I don't believe you're ever going to alleviate the issues of international custody. There isn't, but we have several. We have the Hague. We have the Hague II. Ireland doesn't participate in the Hague II. They participate in what we call Brussels and Brussels II, which covers the EU Union. America does not. The United States does not participate there. So what happens when we allow a child to leave with a parent? Traditionally, state to state, we look at forum selection clauses. It's happened every day in commercial law, and it's happened for a long time in the family court situation, where the parents, they agreed. They agreed before this happened. They agreed prior to leaving to a foreign country. Mr. McAndrew and his wife and the children, with 4 lawyers, 2 on each side, blessed by the judge, they came up with a forum selection agreement that said Rhode Island shall be the law of the land. Irregardless of the forum selection clause, Mr. McAndrew's never left the state. He's never lost ties with his children. So even without the forum selection clause, the Uniform Child Custody Jurisdiction Enforcement Act, what we currently are under today, and the lower court's agreement made a legitimate finding that exclusive continuing jurisdiction still rests in Rhode Island as of today. So the Hague Convention only applies when there aren't current court orders in place. This legislation was passed with a laser focus. The laser focus is when there's a forum selection clause where parents have agreed, and it's a foreign land. It's a foreign land because we can't enforce the orders even if we wanted to without the help. That's the only time, that's the only change that we're making into this law right now. While I don't believe it goes far enough to address some of the issues, I'd like to address those at a future date. Right now, we are at the precipice of, again, what we call, whether what side of the political spectrum you're on, the Supreme Court is going to decide this issue. They're going to decide on the vagity. On the vagity, the current law states that the judge, when hearing a forum inconvenience argument, she's allowed, there's 8 factors that she shall consider. One of those factors is an agreement between the parties. The judge shall consider. But here's the problem for the Supreme Court. They're going to wordsmith shall consider. Does that mean I just looked at it and considered it and I don't have to enforce it? Or does it mean like in commercial cases, in commercial law, which well settled, they say if you find a forum selection clause and you find it's not unconstitutional or it wasn't unduly burdensome, you shall apply it. This is an opportunity for the legislature to determine what you feel shall consider a forum selection clause. My last point that I'd like to make is if this is allowed to stand, that a forum selection clause may or may not be enforceable, you have a situation where every divorce in the state of Rhode Island up until today may or may not be enforceable. Many of them, there's probably people in this room that have been divorced, have a forum selection clause agreement, or maybe you don't. That's really what we're at. Somehow we have in place, again, where Mr. McAndrew and his wife agreed. 4 lawyers present, a judge blessing it, and today it can just be overturned because what does shall consider mean? We need this immediately because what Phil has not told you is there's still a 9-year-old. The 9-year-old is still in Ireland. There's still a 9-year-old. So with that, that's our testimony here today. Thank you.
Okay, any questions from Mr. Gilbert? Thank you, gentlemen, for coming up. Obviously, it's a very sensitive, delicate issue. We will work with Representative Filippi on the bill. Thank you very much. So that will conclude testimony on House Bill 5960 by Representative Filippi. Representative Shikarchi has 2 bills on today. They are 5 5652 and 5653. They both deal with issues at the juvenile detention facility. So we will take them together. 5652 and